Welcome to our program today entitled Privacy and Data Security for Your Nonprofit, Understanding Your Legal Obligations and Ensuring Against Risk. My name is Jeff Tenenbaum, Chair of the Nonprofit Organizations Practice here at the Venable Law Firm. Welcome to our program today, part of the monthly series that we've been doing for about 3.5 years now on a wide array of different nonprofit legal topics. We're really pleased and gratified to have such a great crowd in the middle of August, about 75 people here in the room today and over 200 signed up on the telephone across the country today on our webinar. So we're really pleased that you're able to join us today, and you're definitely in for a treat. We cover, as many of you know, because many of you are regular attendees and participants in our monthly program, so we try to cover a very broad and wide array of legal issues affecting nonprofit organizations, covering many of the issues that we deal with in our practice and representing hundreds of nonprofits every year. This is one topic, though, that we've actually never covered before, so I'm particularly excited about doing so. And we're also always excited to welcome outside speakers, non-Venable lawyers, or non-lawyers, period, to our program, and we're pleased to have one of those with us today who I'll introduce shortly. A few housekeeping matters first. In terms of questions, we're going to take questions at the end of the first half of the presentation, which will be from my colleague Milo Cividanis, and then questions again at the end of Ben Beeson's presentation. So do save up your questions. Here in the room, if you have a burning question during the program, raise your hand and we'll try to deal with that. And for those of you on the telephone, feel free to pose your questions at any time during the program using the chat feature, and I'll pose those to our speakers at the appropriate times. For those of you in the room, there are a couple of handheld mics in the back. Just raise your hand and wait for that microphone to get to you before asking the question so everyone on the telephone can hear your question. Those of you in the room have a handout book that has a printed copy of all the PowerPoint slides from today's program, along with a number of ancillary handout materials, articles in particular, on point. Those of you on the webinar should have been and were emailed a copy of the PowerPoint presentation. Tomorrow, all of you will receive an email containing a recording link, a link to the recording of today's program, along with all of the PowerPoint materials and articles. And as many of you know, all of the recordings of our monthly legal webinars can be found on our YouTube channel, and the link to that is on the last slide of today's presentation. Note, this is new, started last month. For those of you who are in the trade and professional association world and are certified association executives, you can now get CAE, Continuing Education Credit, 1.5 credits for each of the programs that you participate in. We have one scheduled upcoming program. Next month, our program on September 16th is entitled What's Ahead for 2015, Preparing Your Nonprofit's Group Health Plan for the Employer Mandate, an issue that many, if not all of your organizations are struggling and dealing with these days, and I think you're going to find next month's program particularly helpful, and we're in the process of lining up our programs for the rest of the year as well. Let me briefly introduce our speakers. First, to my far right is my colleague and partner, Milo Cividanis. Milo concentrates his practice on helping companies and nonprofit organizations and other entities meet their privacy obligations in a competitive and global marketplace and shape the data protection laws and regulations that govern their activities. He is very much engaged both in the compliance front and in the advocacy front. His practice centers on counseling clients in various industries, including marketing, entertainment, electronic publishing, telecom, retail, healthcare, pharmaceutical, and others, and how to address privacy challenges to their product development, sales, and other business operations. I've had the privilege of working with Milo for a number of years now, and a number of his colleagues in our privacy group. It's one of the country's premier privacy law practices. There's a terrific group of lawyers that Milo and others that we have here at the firm, and you're going to be the benefit of Milo's great expertise here today. To my immediate right is Ben Beeson. Ben is Vice President for Cybersecurity and Privacy at Lockton. Based in D.C., Ben joined Lockton in 2007 and only recently relocated to the U.S. from London, where he led the global cyber risk practice. He's known as a cyber risk thought leader in the commercial insurance market and has been at the forefront in supporting U.S. and U.K. government efforts to improve industry resilience to cyber attacks. Full bios for both of our speakers can be found in your handout materials. So without further ado, I'm going to turn it over to Milo to get us started. Milo.
Thank you. All right. Well, it's good to see Ben here. Ben and I spent some time together on the other side of the pond, so we haven't had the opportunity to catch up here in the D.C. area. So you'll see on the agenda we're intend to cover about 6 areas, and we've kind of split that up in half. So I'll do the first several, and as Jeff indicated, that'd be a natural pause to take some questions, and then Ben will be tackling the other 3 points, and then we'll open it up to questions on any aspect of the presentation. Okay, so the first one is, what are the threats? And so let's get started with the type of attackers that we tend to find. Everybody's not the same, and so what you have here in this slide is an effort to kind of categorize some of the attackers into certain kinds of categories. So the James Dean photo is intended to capture kind of the disgruntled employee, former employee, the rogue. They're not as sophisticated necessarily as others in this roster of the 4 horsemen. They have limited resources. What impact they have depends on what they've done to the company. I've seen some rogue employees do some very damaging things to companies, whereas at other times they certainly can't have the impact on an enterprise and an organization that some of the other folks do. To his right, what you've got is really kind of the hacktivists, folks who are out there. They're focused on a cause. They're trying to get some notoriety for themselves. They tend to work in small groups, sometimes loosely affiliated. And so, it depends on your profile as a nonprofit, whether you would have, you might get their attention, that you'd be the kind of enterprise organization that they might look at. Then what you've got on the right bottom is essentially organized crime. It's the efforts to get at credit card numbers and trying to get at stuff in order to capitalize on that, monetize that, and they tend to be fairly sophisticated, but they tend to give up kind of quickly. That is, they'll try something repeatedly up to a certain point, and then they'll decide, I can get this kind of information somewhere else. And so it's almost like trying to go after money in a bank, and one particular bank is very well protected. You'll go down a few blocks and go to another bank where they're not as well protected. And then left bottom is really more the advanced persistent threat. The advanced persistent threat is often a nation state. They typically are after trade secrets, or typically after something else, maybe learning how something works, how energy grid works, in order to maybe shut it down at the appropriate time for them. So the term persistent is there for a reason. Ben, any thoughts in terms of the APTs, the advanced persistent threats?
Yeah, I think that the overarching message at the moment is that if you're still thinking that this is a guy or girl in their bedroom trying to get who's very intelligent and just spends their whole time on the computer trying to get you, it has changed hugely in the last 3 to 5 years. And APTs, advanced persistent threats, which are now countries trying to get you, state-sponsored, with the resources that they've got behind that, mean a completely different type of threat. I guess that's what I'd say. Yeah.
Okay. Also, it's worth trying to look at, and we kind of reference that a little bit with the type of attackers, the type of information. What is it that gets attracted? And so what you see here also is there's financial type of information that you may well have, either because of You may have a merchant side to you, that is, you're taking payment through credit cards or some other aspect, or bank drafts, or it's information you have in files on donors or members. There's a variety of different types of financial information that can be used and monetized. There's also, again, non-financial information that is also of interest that can be used in terms of from the trade secret side, from a military side. So there's a variety of types of information. And this is going to be important when Ben gets to his stage about what you can do. You have to kind of go in and do an inventory of your own information. What kind of information do you have? What kind of a profile do you have? How attractive might you be as a target? So you might still say, well, but I'm just a nonprofit. I don't have most of this kind of information. I don't really, I'm much of a threat to anybody or much of a profile to anybody. Just in the last couple of weeks, we've got these news developments in terms of over 1 billion credentials that are now been confirmed or in the hands of some Russian hackers. What we'll also find is that attacks often are kind of almost like Trojan horses. You come in a different kind of way, and often the way you come in is through some credential, some login credential that's been obtained from somewhere else. And people, all of us, tend not to have 10 different logins because it gets complicated. We tend to kind of use the same logins, at least in clusters. And so often something that may be pretty simple, I don't know, a login credential for online access to a newspaper, New York Times or Wall Street Journal or the Washington Post, might end up being the same login you're using somewhere else, and people can use that, and there's an interconnectedness. So it becomes the world is so interconnected now that there's a lot more value, and it's much more interesting. Now, what you might have might be of greater interest than you thought. In fact, California, which was the first state to pass a law a little over 10 years ago to promote data security by requiring notification of breaches of unencrypted information, is really intended to get everybody to encrypt. And instead, what we've had is a slew of breach notifications as more and more states adopt that, and now other countries are thinking about it. But it was really intended to get everybody to encrypt, because if it's encrypted, there's no obligation. Well, California is one of the first states to expand the list of information that's subject to that type of treatment. It used to be that if you had a name coupled with a Social Security number, a name coupled with a credit card number, that was considered sensitive and required notification in the event of you had a breach. California has now expanded the list of information to also include a username and a password. That if that has been compromised, if you have that and that's been compromised, that now is subject to breach notification. You have to notify the AG's office. You got to notify all the affected individuals, and that again is because the sense is login credentials have become, even to fairly innocent type of activities, have become a potential key to other more sensitive databases.
Something happened in Florida as well recently along those lines, did it, Milo? Expansion on the definition of PII? Or?
Yes.
Similar, sort of following California?
California starts it, and then other states will follow. Yeah. Okay. So then, and before we leave this area, this topic, I just wanted to mention, last week as I was driving, I heard a story from National Public Radio on All Things Considered on a small group of Silicon Valley entrepreneurs and developers who are trying to build internet systems and business models that collect as little personal data as possible. And I thought there was just this one soundbite that captured so much of what can happen when you have information. And the soundbite was, the host Steve Henn said, "Data attracts hackers, identity thieves, cops," I'll come back to that, "courts, stalkers, Chinese military hacking collectives, Russian mobsters, an intelligence analyst from the NSA. And that's really, in one soundbite, really captured all these people out there just waiting to get into places. The reference to courts and cops is that, again, also there's all kinds of law enforcement requests that are not a hacking issue, but an issue of preserving information and having people come and ask for it and request it or demand it through legal process. There can be, civil suits, divorce cases, et cetera. Again, there's a lot of ways that the information you have may be of value to somebody else. They may try to get to it through legal means, or they may try to get to it through other means. But again, that soundbite really, I thought, captured most. I'm going to turn next to kinds of the risks to nonprofits from problems in terms of data security. So the first is, well, it may be, I'm not sure how many people, everybody's anonymous here now, most of you know each other, but how many of you have been at an organization where you've experienced a data breach? Any? Okay, I see some hands in the audience. It is a crisis at the time when it happens typically, and it's the costs associated with that it can be very substantial. You'll see in this slide that we listed several of them. I mean, you have to bring in people to kind of get a better understanding of what's happened. There's often, in order to deal with breach notification, for example, you may expect questions back from calls from people that you've notified, wanting more information. If you don't want to just say, sorry, we lost all this information on you, have a nice day, you might have to set up, decide as a business matter, not as a legal matter, that you're going to set up some kind of credit monitoring or something so that you're offering something to kind of soften the blow. It's something that's almost become industry practice, but I'm not sure it's covered by insurance necessarily. When you get to that stage, right, if it says required by law, it may not be covered by insurance.
Don't steal my thunder.
Okay, sorry. So you've got a number of costs associated. Some of it insured, some of it not, maybe. And so there's a substantial cost involved with that kind of a privacy or data security breach. The reputational damage can be very substantial. Just when I think that the headline-grabbing sense of a data breach is gone by, that everybody's kind of used to it now, it happens so often, something else, something unique, some aspect of it is different, and it gets attention. And then because there's a feeding frenzy, every little type of breach that a neighbor learns about, who's a reporter, they get it into the local TV, they get it into the local news, and it gets around. So the impact on your members, on your donors, and or their reaction, the impact on you, it can be very, very substantial.
Milo, can I interrupt you for a second? We have a question from the webinar. With respect to these data breaches, how important is it for an organization to have policies and action protocols in place before an incident occurs?
Ben, are you going to get to that?
I am.
Okay.
We will get to that, actually.
Okay.
All right.
All right. We'll get to your question later.
Yep. I've stolen some thunder. I don't want to steal any more thunder here. No. Okay. I think I went through too quickly. Yes. So another aspect is the government comes around, looking around. The consumer protection side of government, those are attorneys generals, the Federal Trade Commission, and for many businesses. And even though the FTC has limited jurisdiction over nonprofits, subject only to certain statutes only, they set the stage. They set kind of the trend for a lot of the state AGs, and state AGs are very active in this area. And there's fines involved. There's changes in business practices that come out of that. So it can be very substantial in various ways. And in some areas, HIPAA, Ben may get into the fines, even for nonprofits, can be very substantial. And then finally, not to be left out, of course, there's the lawyers and the plaintiffs bar seeking money, seeking new models, coming up with new models for recovery for any kind of data breach or privacy related breach. And maybe this might be a good time to make a slight comment on a slight difference between privacy and data security. And I try to capture it with just kind of one word each. I think of privacy as push, and I think of data security issues as pull. By push, I mean typically with privacy issues, you're making decisions about the information. A real simple example is you're deciding to monetize your list of members, and so you're going to rent that. You're going to get some money from that, and so you're making decisions about the information. You're pushing the information in certain directions within the organization, outside of the organization. Whereas data security issues tend to be, I think of something siphoning away, right? Vacuuming away information from your organization, pulling it away from you at a time when, in a situation you didn't expect it to. That's not what you wanted to happen. You can't have privacy without data security, but they are a little different. And although, again, in the press and part of our conversation today, we'll treat them the same, there are some differences, and we'll see a few now. But I just wanted to kind of highlight that difference. So in terms of some of the trends we're seeing, there's more data being collected. There's just the cost of storing data, the cost of processing data, the value of what you can do with data is increasing. So people or organizations are collecting more and more data. And that leads to many good things, but now you've got more and more data. There are growing uses of data. Again, these all kind of are related, but as there's more data, there have been the term big data is being used now, and the government's done a study and a report. It's all about crunching the numbers, understanding your members, your donors, understanding trends. So more and more data is being collected, more and more data is being used. You typically can't do all of this yourself, and so more and more data is being transferred, more and more data is being stored. There's more and more people having access to this increasing amount of data that's being collected and used. And again, in and of itself, that's not bad. Again, these are for good purposes. But as you can see, there's opportunities for mischief. There's opportunities here for problems. And last, and I made reference to this earlier, there's interconnectedness of these activities. These things together add value. So whereas before a name and a telephone might only have a certain kind of value, now as part of an effort to create an identity, to persuade some enterprise through their customer service or member service that they are somebody else, having a name and phone number adds now more to the profile. Whereas before it was just maybe for telemarketing, now there's added value to it that wasn't there before. And so you see, again, there's this additional value that's going on. And ultimately, I guess the message is, there are people, and again, the headlines of the 1 billion credentials underscore this, that are finding that it's a lot easier to rob, to engage in crime, by sitting on a computer and doing code than it is by getting a gun or a rifle and trying to steal and rob. It's just because of all the data and because of the interconnectedness of the data. Get at some legal developments that are worth highlighting. So what we're seeing in the headlines over and over, last Christmas was a big one in terms of department stores into other retail establishments and hotels and variety of areas, hospitals. You're seeing it over and over. They're getting attention, and whereas Congress and state legislatures were kind of done, one could say, in some respects, it re-energizes them. They find new problems to address, new solutions that they want to pitch and get in and codify in the law and pass whole hearings about. So it becomes, a greater issue here. And so that's the one important aspect is that there is increased attention. It's just kind of they've turned a new page and are more energized and more interested in these kinds of issues than they might have been just a year ago in many respects. There's an expectation that given this kind of warfare, that all of us have a greater duty to protect things. And it used to be under kind of tort law issues, the focus was primarily what's foreseeable, and what steps you had to take to identify what's foreseeable, what problems could arise were more limited. But there's a greater effort now to impose more and more expectations of all of us for this. So the Securities and Exchange Commission, for example, that doesn't govern any of your businesses, has just put out an examination template with a series of questions that they're going to be asking all businesses eventually during an audit kind of process, which, by letting everybody know in advance, everybody's beginning to asking these kinds of questions. The federal government went through a process through NIST and came out with a framework that I think Ben's going to touch on or respond to, and it's designed for. It was initially intended and designed for critical infrastructure players. So think about telecom, think about water, energy, a variety of areas. But it explicitly says it can be adapted for any enterprise. It's not just for critical infrastructure. And it essentially calls for the development and implementation of a risk management program. And it sets out 5 core functions that should be taken in the front end, in terms of getting your arms around the cyber risk management. And they are, number 1, identify. And I'm not going to elaborate on these because I think, again, Ben, you're going to touch on some of these?
Yeah. I mean, if you want to go through some of that, that's
well, fine. I'm just going to identify them because I think
Sure.
I think you're going to get them on the risk mitigation side.
Yeah, absolutely. And I guess I'm going to talk a little bit about why that's happening as well. Yeah.
Okay. So essentially identify your assets and your resources in this area. Protect. Detect. You're not going to be able to succeed at protecting everything, so detect when something's happening. Respond to that. And recover. What do you do to bounce back? So that's kind of the basic elements of that proposed framework. It's got also suggestions on implementation and things like that. But the takeaway here is essentially that the government is speaking, and we're beginning to see this now. The federal agencies are expecting this of vendors that interact with them. We're seeing some of the like the Federal Communications Commission is speaking about this in terms of what they're expecting the companies that they regulate to start thinking about, mostly in a reporting kind of way. But again, kind of the SEC, tell me what you're doing. Well, if you're not doing anything, there's a problem, right? So in order to report, something to say when those kinds of questions come, more and more companies are going to be doing more. And as more and more enterprises, more and more companies do more of that, some of them members maybe, of your associations, that's going to, that's just going to be passed on to you, and these expectations will be expected of everybody eventually.
Yeah, and I would just add to that I think that if you're a non-profit, you shouldn't be of the mindset, well, that's critical infrastructure industries, that's not relevant to me. The message is that government now here and actually globally, they're very concerned about this issue. So they're taking, there's additional scrutiny that's happening. This is a first step that the NIST Framework just launched in February. and it isn't mandatory, but I think what you're going to see is there's going to be a growing expectation that you need, whoever you are, to get your house in order when it comes to cyber risk, and specifically what we're talking about today, data security and privacy. So that will manifest itself also through contracts, as Marlo was saying, particularly if you're a service provider, but it will come to the non-profit sector as well, no doubt about it.
Yeah, and in fact, it already is. We're seeing it in the nonprofit world increasingly regularly with federal grants and contracts that are awarded to nonprofit organizations, particularly where there's critical data involved. The agencies are asking and sometimes even requiring specific protocols and other protections to be sure that information and data is well protected, and that's not surprising. It's like Milo said, it seems to be coming kind of from across the federal government and at state governments as well, and nonprofits being some of the biggest recipients of particularly federal grants, but also contracts. You can't fall asleep at the switch with this, and as Ben's going to talk about, you really need to be proactive in getting policies and practices and protocols and other things in place before a breach happens. Actually, can I say one thing? I neglected at the beginning of my welcoming comments today to recognize Lockton Companies, who's co-sponsoring this program with us today, and Keith Mulvihill, who's here in the room somewhere. There he is, right there. Helped to put this program together with us, and thank you very much to Lockton for co-sponsoring the program with us today.
Thank you.
Ben indicated again, those standards are really the first step. This slide's trying to highlight the second step. That is, right, once you set those standards, somebody's going to go and check to see whether you're complying with them, whether you're meeting those requirements. And so, again, the government and others are going to be certainly looking at these to make sure that the standards that they're promoting are being satisfied. And again, whether they have a big stick or in terms of some kind of penalty structure because you're subject to these obligations, or a smaller type of club because through contract negotiations or other aspects, these things are going to flow down, they're going to be passed on and expected. And then in terms of the privacy landscape in particular now, wanted to highlight that this constantly changes. A decade or less ago, there was the notion that personal information or personal identifiable information, was kind of a name or a social security number, something rather unique, where someone could eventually identify who you were, call you, go to your home or something like that. And so the notion, for example, that an internet browser, remember the old New Yorker cartoon, the dog's at the computer, I don't know who's behind the browser, who knows who is there. Maybe I can deliver an ad to that browser because that browser is doing certain activities. They're searching for hotels or something, so I'm going to start adding hotel ads to my inventory to that browser, but I don't know who's behind that browser. Now what we're seeing a lot because of mobile type of activities, but there's an erosion or an evolving sense of what's personal identifiable information, what's PII, and it's becoming more, and the answer is more and more information is being considered personally identifiable information. In California a couple of years ago, you may know of a law called the Song-Beverly Act. It applies to, essentially, the policy is that individuals should not have to hand over the personal information as a condition of using their credit card. So the credit card it prohibits the collection of personal information at the point of sale in connection with the credit card transaction. And the issue was whether a zip code, just a zip code, was personal information when collected with a credit card. And it went all the way up to the state Supreme Court, and the state Supreme Court held that it was. And so again, the evolving notion that more and more things are considered personal information has very significant implications, again, more on the privacy side of things. So to summarize, in terms of the landscape, the threats, I just wanted to go over. So we've got the key risks to nonprofits are from a breach in terms of the cost of a breach, the reputational harm, the government type of fines or exposure, the class action lawsuits, the developments we talked about, the trends in terms of increased data collection, use, transfer, value, interconnectedness, and then in terms of legal developments, again, the higher interest that law enforcement and policymakers are taking in this issue, or the renewed interest they're taking in it, the development of standards, cyber standards that's coming from various government type of sources, the increased enforcement by government in some of these areas, and the shifting and evolving expectations of privacy. That's kind of sets the stage. That's the kinds of issues and risks that that all of us are facing. The second stage is Ben, where he's going to focus on potential solutions, ways of addressing and fixing this. But if we want to take...
yeah, just a couple quick comments to add to your final slide there, Milo. I'd probably maybe add even another risk, at least for certain nonprofits, and that's the risk of debarment or other disqualification from receiving future federal grants or contracts or state grants or contracts. And secondly, you did mention, and this is an issue that has been discussed widely in the past, who is the primary kind of federal regulator of privacy? And I'm not sure there really is one, although if there's a first among equals, I'm sure you would agree it's the Federal Trade Commission. But certainly as we've seen and as you discussed, there's a lot of other federal agencies that are definitely getting their hand in the privacy mix and pushing requirements and standards and expectations on down, including to nonprofits. A Federal Trade Commission generally does not have jurisdiction over bona fide nonprofits, but it does have jurisdiction over nonprofit, tax-exempt trade and professional associations. And in addition, even for bona fide 501c3s, while the Federal Trade Commission may not have jurisdiction, to the extent that it sets standards and expectations for what it considers to be reasonable and expected conduct in the privacy area, those standards are going to kind of set the legal bar for all organizations from a private litigation perspective.
Certainly from the state attorneys general. They very much.
Exactly, and state attorneys general definitely have jurisdiction over bona fide C3.
And they look to the FTC for suggestions and standards. Exactly,
and that's why a lot of our clients who are 501c3s, often say, well, we don't have to worry about what the FTC says because they don't have jurisdiction over us. But as we've clearly seen in this area and in others, you do have to pay attention, and we constantly reference, not just in this area but in others, FTC guidance and standards as best practices to follow because it does have legal implications in other areas. Okay, with that, I'll turn it over to Ben.
Do we want to take any questions?
Yeah, good point. Yeah. Anyone have any questions for Milo and anything we've discussed here today? And if you don't have any at the moment, but you have some for Milo later, we'll definitely leave some time at the end. All right, let's move on to Ben right now.
All right. So now that Milo's put the fear of God into everybody, you probably think that this is going to be the old good cop, bad cop routine. And I'm just going to sit here and tell you, don't worry about it. It's all going to be all right. Here's how to fix it. For once in the Hollywood movie, the Brit gets to be a good guy. It's about time. But that Jaguar commercial, it's good to be bad. Yeah. Well, unfortunately, I'm here to tell you that I've been typecast. So it isn't all great news, but there are things that you can be doing to mitigate the risk, not prevent it, as I'll start discussing, and ultimately transfer it off your balance sheet if you so choose and insure it. So there is no silver bullet, unfortunately. Everybody is getting hit. Nobody's safe. If the bad guys want to get you, they'll get you. I mean, that is the message at the moment, I'm afraid. You really only got to see, as Milo touched on, what came out last week. I mean, think about it, over a billion usernames and passwords. I mean, that number's pretty crazy, isn't it? From apparently over 400,000 websites. I think that gives you a feel for what I just said. That's evidence. And the second thing that's evidence is what Milo just started talking about with regards to government attention to this problem. We didn't really see that until 18 months, 2 years ago. This country has started that. The insurance industry has been directly engaged with the federal government on this issue, and in both the creation and now the implementation, working with DHS, of the NIST framework that we've touched on. And I won't get into that anymore. Suffice to say, expect that to be step one. And regulatory scrutiny will be greater. In the UK, just to give you a flavour, there's something called Cyber Essentials, which the UK government's just launched. They've decided that they don't want to target critical infrastructure industries. I think it's mistaken, personally. They're just going to go after really small businesses who tend to have lax security controls and give them the basics to really sort of improve what's called their cyber hygiene. So this is not just about what's happening in the US, it's a concern globally. So you then may say to me, oh, well, I'll just hold my hands up. Why bother? We're going to get hit. Why bother? Why invest any money in security? Why buy insurance? I guess two answers to that. One is, as you're going to hear, this is a governance issue. It's a regulatory issue. You don't really increasingly have that choice for that reason. And secondly, you can do a lot to mitigate the risk and really not make yourself a target. Part of the reason why 1 billion usernames and passwords are out there from so many firms is because people just aren't doing what they need to be doing. Make it hard for the attackers. Don't make it easy for them. They'll go away. This is about resilience, okay? It's about, accepting that they're going to get into your network, but then shut it down. And as I'll talk about, without getting too far ahead of myself, do things that makes it hard to them when they're inside the network to get what they want. And that's an important message here, and that's an important mindset to have in how you tackle this problem. So what I'm going to do is really two things. One is lay out 10 steps, really, that you can take to tackle this problem, a way to approach it from mitigating the risk. And then I'm going to end on that by saying, on those 10 steps, by saying, insurance is one of them, and then we'll move into why you should consider that, why would you transfer the risk, and then how would you go about it, and what do you need to be thinking about. And then finally, I'll just end briefly with just, if we have time, just on one or two things that are coming over the horizon, just in case you don't think we've got enough to think about. So let's move into those 10 steps. So I think that, you may have heard this. If you've looked at this problem, it's becoming a little cliched, and apologies for that. But if you haven't, then it's probably this and step two are the most important things that you should be thinking about. Do not think that this is a problem for the IT department. Arguably, the IT department is the biggest stakeholder, absolutely. But if you leave it to the IT department, you are actually not doing what you need to be doing to shut this down. This is actually, in many ways, you want to think of this as a people risk, I'll just give you a couple of examples. What are you doing with your employees, for example, in terms of training them, in terms of privacy of the donors and the PII that they give to you? What access do they get to that type of information or credit card information? That would be a good example about where that might not be something that would sit within IT, but might sit within HR. So just one example of that. But that is very important that you think about. Legal, probably, I would argue, is as big a stakeholder. Music to Jeff and Milo's ears. More work, thank you very much. But they are. Legal has a big part to play in this, both in terms of how you mitigate the risk, and I'll come on to and really answering the question that Jeff was asked earlier, in terms of how you respond to a problem when it happens, when a data breach happens.
And maybe one comment to add on your first point. about the fact that this is not just an IT issue. One of the programs that we did as our monthly seminar webinar a few months ago was about bring your own device programs and all of the various legal issues and HR issues that come into play. And one of the things that we touched upon in that program, our colleague AJ Zatola was leading this discussion, was on the privacy and data security issues in that area in terms of employees using their own devices, iPhones, laptop computers, and other things where they're getting access to the nonprofit organization's network and using it to carry on their organization's business via email and elsewhere. And you're exactly right. The protocols and protections may emanate from the IT department, but this is very much an issue that HR deals with, that legal deals with, and so many other departments within a nonprofit organization.
Right.
And if you, by the way, if you're interested in that webinar, on the last slide you see the link to all of our recorded webinars. It was a very interesting program that may be worth watching and listening to. Thanks.
Yeah, great. Thanks, Jeff. I'm glad you agreed with me. And the second point here, or the second step, really ties in with step one, and very topical in our industry at the moment. Perhaps Target is the biggest example of this, about why this is a boardroom risk now. And it's not just about it's a boardroom risk, but actually you need to tackle the risk in the boardroom. And that's easier said than done, of course. But really it does, the approach to this risk needs to come from the top of the company down. It can't, as we just said in step one, it can't just sit in isolation in the IT department and be part of their budget. Now, what is happening? I mean, one example, one question you might want to ask yourselves is, at the moment, is there any communication between the IT department and the board? How does that happen? And if there is, are the IT guys speaking in acronyms? Does the board actually understand what the IT guys are saying? We know the IT industry like to talk in acronyms, and that's absolutely fine. But really, there's one thing saying, okay, we'll tackle this from the top down. Okay, how are you going to explain in layman's terms what the issues are to the board? Or alternatively, are you going to have somebody on the board who is technical as an alternative to that? So, those are your options. That, for a public company particularly now, is becoming almost, you have to do it under what the SEC, and the way, Milo was talking about with regards to the SEC. There really is no choice now. And for you, I think, it's best practice, it's governance, it's what needs to happen. And also thinking about aligning that with the business strategy as well at the same time. I think that's important too. And of course, the board will be very good at that and can help with that, so that security and strategy of the business are aligned. That's very important. You don't want one thing going off here and the other off there. You really aren't making best use of your resources if you do that.
Yeah, Ben, I would say that some people may ask, well, for a nonprofit organization, is this really a board issue? Isn't this just a staff issue? Does our board really want to get in the weeds on things like this? And to a certain extent, there's probably some merit in that point, in that you certainly don't want a board micromanaging things like your privacy and data security policies and protocols. At the same time, when there is a serious data breach, which we've seen in a number of our clients, and we've handled internal investigations and other things like that, the board gets very interested and very angry and wants to know what happened and what went wrong and what can we do in the future to fix this. And so looking at it from that flip side, it would seem to make a lot of sense to at least keep the board in the loop, let them see what you're doing, let them see that you're being proactive and on top of these issues, not necessarily having them micromanage the process, but keeping them a part of the process.
This is a slide, step 3, where clearly any organization wants to identify, what are their critical information assets? What is mission critical? Now, for much of this audience, that's going to be things like donor personal information. It's going to be employee payroll, possibly, protected healthcare information. that type of stuff. And that's certainly where we're focused today. And that is attractive information, as Milo has pointed out, to a hacker or a rogue employee, by the way. And so it's important that in that discussion, either at the board level, preferably, you understand what is critical to you, and this clearly would be PII and PHI would be part of that. And then what are you doing, as we'll just discuss in a minute, to lock it down, essentially? I mean, Marty, do you want to add anything to that on that? I mean, or Jeff even as well, because in the non-profit sector, would there be anything else that you would think would be important to consider?
Sure. I mean, there's all sorts of critical data, depending on the type of organization. There's obviously simple things, donor information, member credit card information when members use credit cards to pay membership dues, to pay conference registration fees, to buy publication when donors are making charitable contributions to a nonprofit organization. Those are kind of pretty basic, but there's a lot of other information too. For instance, a lot of organizations, trade and professional associations, even a number of our 501c3 clients, gather a lot of information from their relevant industry or profession or the relevant community that they work in, and then do things with that information to gather it up and aggregate it and report it back out, and that data is used for a variety of purposes. A lot of times that data is very sensitive, and there are antitrust and other considerations in terms of how that information is compiled and then spit back out. And if there was a data breach with respect to that raw data, it could be extremely dangerous to the organization. But there's countless examples. As we know, we work with about 600 different nonprofit organizations every year. Almost every one of them has different ways, different types of data that they collect and that they have to protect. So there's no shortage of examples. And then don't forget your employees as well. That's critical data with respect to your own employees.
Step 4, vendors, warrant a slide all on their own, particularly business functions you outsource that would involve, for example, PI or PHI, whether that might be of your donors or your employees. So, think about payroll, think about payment card processing as being, important examples. Think about the cloud increasingly, and whether you've looked at or already doing things like data storage, with a cloud provider. I'm going to ask Milo as well to weigh in here, because a lot of this is a legal issue as much as anything. What is your, and we'll get into the insurance aspect of it in a minute, but very often, what does your contract look like with those vendors? Very often, as I'm sure you've experienced, you may try to transfer a risk of a breach of privacy or a data breach, when the vendor's at fault, and you're liable, at least in the first instance, to notify those individuals. You have that vicarious risk, you cede it control, so you try to cede that risk under contract. I mean, what are you seeing there, Milo, in that particular area?
We're seeing more and more due diligence of looking over existing vendor agreements as well as new vendor agreements. We're also seeing kind of a categorizing of vendors in terms of what access they have. In some organizations, the larger ones, typically will reserve the right and will conduct, some kind of an audit of some sort themselves. And it'll be part of the cost of the arrangement. And they'll, rotate over the years different vendors, but as to who they're looking at. A substitute for that is, which is the next kind of level of vendor, is to also ask for their, the results of their audits, right? Of their assessments on industry standards, and so not to incur the cost, but to trust and be relatively satisfied that they've done the process and they've got some kind of a clean bill, or if they had to mitigate something, they fixed it, and now they have a clean bill. So you ask for kind of proof, so to speak, that they're meeting the industry standards. So there's a variety of things that go beyond the contracts, although the contracts are the starting point for that. If there's nothing in the contract, then you've got nothing to seek relief or seek some kind of proof that they're working within industry standards.
And Milo or Ben, question from the webinar. In drafting contracts with vendors that will electronically store data for us, what specific standards should we propose that they abide by?
Well, it partially depends, but the ISO standards typically are the ones that are referred to. ISO is just a global type of standards that they have different ones for different types of activities, and the ISO 7200, right? 71. I mean, there's a variety. There's a couple of them that are most appropriate in the data security and personal data type of protection side. And they're adaptable. They can be for smaller organizations, for bigger organizations, but typically that's the type of standard that would be used.
Thanks, Milo. And I think you can add to this, and understanding, of course, that it's a negotiation with vendors. You can't just get them to do it. I think we know cloud providers, particularly, are notoriously difficult in terms of assuming any contractual risk at all. They understand the issue around a data breach. They've got a lot of that data. Try to get as much as you can under contract. Try, if you can, to get the vendor to buy insurance for this issue. Insurance is an asset. Think about how other clients of that vendor could be making a claim on a breach on a data breach that may involve other clients' PII. So how much money, could that put that vendor out of business, for example? So could you get the vendor to buy insurance? So something to think about there.
Ben, there was a question from the audience. Will vendors issue nonprofits a certificate of insurance if requested, naming the nonprofit as an additional insured under their policy?
So will vendors? Well, I guess.
And obviously, it's on a case-by-case basis. But can you just speak generally to the issue?
Yeah, I mean, on an insurance policy, yeah. I mean that the answer is from an insurer, they'll do that on a case-by-case basis. Would the vendor accept doing that? I guess that depends on who has the stronger relation. Who's muscling who is probably the way to put it.
Who's got the greater leverage?
Exactly, leverage. Exactly.
Yeah, and we deal with hundreds of vendor contract reviews for our nonprofit clients each year in the technology area, dealing with a really big one right now involving a vendor that's going to provide a whole host of credentialing and licensing type activities with a lot of very, very sensitive data, and these points are some of the toughest points in the negotiation. And you're right, like any contract negotiation, so much is about leverage. Right. There was a question right here. If you could just wait for the mic, Marion's on her way.
Does a typical SOC audit cover cyber liability issues these days for a vendor?
I haven't. They typically try to stay on top of industry changes and some of the standards. I'd have to. I think I'd be reluctant to say yes until I looked at at the latest version that they're using. I mean, for example, just to give you an example, in other areas, how they're changing, again, the standards and what's a PCI, which is another type of thing. They've just announced, new standards, and they're trying to work on new standards for vendors. So it's so moving. You want to make sure that if they're applying the most recent, SOC with the most recent standards, you're more likely to be okay. But you want to make sure that they are using the most recent, standards.
Milo, can you just explain what PCI is?
If you like, I can do it because I'm going to come up to them in here. Step 5 really plays to its resilience. It's not prevention. The guys are going to get into your network. What do you do then? So you've got a firewall to protect your perimeter. Okay, they've got through that. Have you got an intrusion detection system to know where that they have got through? What else are you doing? Do you have antivirus software to pick up the computer virus if it gets in? Do you encrypt? Perhaps the most important thing. Do you encrypt the data that you don't want stolen or exposed? And if you do encrypt it, do you encrypt it at rest, in transit, on portable devices? What do you do? So it's important to think of this, and many of you will be doing this already. Most IT departments, if they're worth their salt, do this, and but I think it's an important thing to say to back up the fact that you need to have a number of defenses against this issue, technical defenses, if you like, in this specific area.
If I can add, just on the detection side, and it goes back to your question, so if they're going to get at us, why bother? And
right.
There was a chief security officer that I thought got a pretty good sense. He said, listen, I can't stop it, but there's a difference between hemorrhaging and bleeding.
Right.
And if I can figure out they've gotten into me and they've only been able to take out a certain amount, that's a lot better, right? If I can detect it early, if I can manage and control and minimize what they've taken, that's a lot better than they took everything, and I didn't know about it until a year later or something. So that's part of the effort is you may not be able to prevent it entirely, but there's a lot of things, a lot of hurdles, a lot of things you can do, tripwires to kind of figure it out at sooner rather than later.
I'll push on a bit because I know we're getting short of time. But portable devices and step 6, it seems an obvious one, but I can't tell you how many data breaches we see, from a lost laptop or a stolen device. If you are allowing payroll or donor data onto a portable device, then you really should encrypt that if you're not already doing that. Technically, correct me if I'm wrong, Milo, a stolen laptop with encrypted PII or PHI is not a data breach?
Yep, that's correct.
Pretty much right? Yeah, okay. So, I guess step 1 is, if you can, try not to let that data sit on those devices anyway. 7 really, and it's really coming back to Milo's piece and Jeff, PCI DSS, payment card industry data security standards. This is really where the credit card associations, Visa, MasterCard, have got together to impose their own security standards, if you like, with consequences in terms of fines if you don't comply. And I'm sure you all know about that. If you don't, I'll be surprised, and what that means, because there's been a huge focus on that over recent years. You'd be surprised to learn that although you are forced to comply in other countries outside of the US, how many people still are not PCI compliant. So it's important. That would be a very relevant one to this audience. HIPAA for healthcare. I would say the data breach notification laws, are perhaps in many respects the biggest thing you have to grapple with. Because if you think about it, when you have a data breach, it's not about where the breach happens in terms of how you deal with it. It's where the individuals whose data has been breached are domiciled. That's a very important distinction. And so that means that you have to, if you have obligations under state notification laws, it's under the state that the individual is domiciled. That makes it very complicated, in terms of how you respond to this, which again means you've got to get a lawyer involved. You have to have your legal department obviously involved internally, but frankly, increasingly, you need experts from the outside who know how to handle this, and they do exist. But it is, if I really feel the problem starts in many respects when something goes wrong there. I mean, that is a real challenge to any organization. Whose data has been breached and where is it from? And that's unique to the United States in terms of how that sort of is set up. Anything you want to add on that, actually, Monica? No? Okay. Step 8, and this, again, goes back to the question that was asked earlier. Yes, you do need to get your act together before anything goes wrong. And probably the most important thing, or one of the most important things you can do, is establish a data breach incident response plan. What am I going to do within my organization when something happens? How am I going to find out about it, and how is it going to get reported, most importantly into legal, frankly, for what I've just said? And then how are we going to deal with that in terms of notifying affected individuals? How are we set up? Do we need vendors to help us on that? Do we need two things importantly? Do we need a legal counsel, external counsel to help us with that for the reason I just mentioned? And also IT forensics is very important. Very often when you have a breach, well, firstly, you may not know about it. If you do find out about it, you really don't know what's happened, whose data has been compromised. Do I need to bring in an expert to help me with that? So, you really need, and our insurance can help with this, and we'll talk about that in a second. You really need, those are very important relationships to have in how to deal with this. PR as well, you could argue, is important too. And do you need a PR agency on hand as well to help you manage what Milo was talking about as one of the four key risks to a nonprofit, the reputational damage, and how can they advise you in terms of mitigating the reputational fallout to your organization?
Another reason, by the way, in terms of getting forensic help for something that is very threatening is it's a crime scene, and so often we see the IT team going beyond the initial, which is stem the bleeding, stop that, but then they continue to probe around. It's like an emergency responder trying to do brain surgery. You want to bring in folks who can really figure out what happened, and and treat it like a crime scene.
Yeah, absolutely right. Which can sometimes mean there's a real sort of tension between disclosing and not disclosing if you're not able to. I guess no one can talk about that, though, can they? Excuse me, back a step. Just quickly on step 9, I think that this is something where we're going now because the threat is frankly so bad. Defense in depth type strategies on this are increasingly becoming not good enough, and actually active threat monitoring, intelligence-based security, understanding who's trying to get you and what do they want is the future. It's already starting, and you're starting to see certainly bigger organizations start to adapt their approach on security in this way, and I think you're going to see this become more and more topical, because just a defense in depth approach, at least from an IT standpoint, isn't going to be enough to stop this or mitigate this enough in the way that you could be doing. It's expensive at the moment for many organizations to take the approach in step 9, but hopefully that'll change. But to get that type of expertise is not cheap.
Actually, Ben, let me stop you there because it's a timely question from from the webcast. If you're a nonprofit, how do you prioritize privacy? If you only have so much budget, what's most important to do first? What's most important to do second, et cetera? And obviously, the answer to that question is in part going to depend on the nature of the organization, what its programs and activities are, what types of sensitive data does it collect and maintain, et cetera. And that's going to vary.
Well, I guess why don't we both answer? You go first, go on, you go.
Well, I actually think it interconnects a number of things that Ben was saying. I mean, you got to figure out, as Jeff indicated, what data did he have? So that helps you identify kind of what the risk is. If you need more budget dollars or a greater proportion of the dollars, you got to get the board support for that in terms of within the organization, and then the board support in terms of the budget. So having the board involved and invested and understanding the consequences of not making that upgrade this year and pushing it off for a year or two, all of those things are aspects that need to be maybe discussed and get champions on board. But once you figure out what you've got, then you got to figure out again, kind of, how state of the art is it? Are you working on some, classic examples? You're working with something that's no longer supported by the manufacturer, by the software, and so the patches aren't available, a variety of things like that. So there's a number of things that you got to work with your IT team, you got to work with your HR team. Well, again, what kinds of threats? Where's the data? If you're moving towards a bring your own device type of an approach, that raises some issues you need to address. And so you want to work all of this together. It's hard. There's no one answer. I guess is the short is you've got to kind of. I think of it as kicking the tires of your car, and then you figure out what do you need to fix on your car? I don't know until you kick the tires, walk around, figure out is it a paint job? Is it new tires? It all depends. But you got to start, and there is a checklist of figuring out what you have and how current things are, where you're going in terms of models, of new initiatives, But there's no one answer, unfortunately.
Yeah, I mean, I would just give a simple analogy and say if you're Coca-Cola and the guys hack and they get hold of the secret recipe, your intellectual property, I'm guessing if you're Coca-Cola, that's the number one information asset that you want to protect. So in the not-for-profit world, think of it also. What is going to really have an impact on my organization? IP perhaps isn't such an issue in this sector, but PII and PHI clearly are major issues, particularly your donor PII. I think I'm guessing that for many of you, that's going to be right up there, and thinking about maybe I'll put my resources around what can I do in that area to protect that type of information.
Yeah, and think broadly. It's not just necessarily donors. There's many hundreds, if not thousands, of nonprofits, say 501c4 organizations that are active in the lobbying and political activity area, and that are structured in that manner in order to protect the confidentiality of their donors.
Right.
If that information became public, that could be extremely damaging.
Right.
So for each organization, those risks are going to be different. A quick question for maybe both of you or whoever wants to answer. One area that we've always done a lot of work with in nonprofit organizations is what we like to call record and information management policies, historically maybe called document destruction policies or record retention policies. And it's an area that none of our clients ever get excited about delving into this area, but it is critically important. But my question is, how much does that kind of intersect with everything that you're talking about here today? And if you're evaluating your record retention policy, should that be done kind of hand in glove with your privacy and data security policies?
In the ideal world, yes. There's something called fair information practices, and one of them is, limit the amount of information you collect. And the flip side of that is limit the amount of information you store. So, if you no longer need information, get it out of your system. Wasn't the Sony PlayStation? Was a whole bunch of expired credit cards. I mean, it was just, and that just brought so much bad attention to them and all kinds of problems. So yes, absolutely, ideally, but the other thing is execution. If you can't coordinate, then just, don't wait until you can coordinate, and don't wait for paralysis. Get going, do stuff, do the data detention and destruction, do an assessment of what you've got. But ideally, it would be great to have them work together because they are related.
Step 10, consider buying cyber insurance. We got there in the end. So why would you consider buying cyber insurance? Well, I think, you've heard me bang on about this quite a bit already. Despite everything we talked about in the 10 steps, you could still get hacked. And it's really then about understanding what does that residual risk on my balance sheet look like, try to understand that, and do I want to insure it? So that, what I would call that severity risk, that really big hit, it isn't really the dollar swap for sort of minor loss of information, if you want to put it that way. It's a lot of data that gets compromised. Again, you're liable, remember, when you cede control any time to a vendor, you're still liable very often. If it's your donor or a member or employee, PII, PHI, you're typically liable to notify them first and incur those costs, and then you may want to try and get those back under contract. Insurance actually doesn't make that distinction. If you bought an insurance policy for that vicarious risk to your vendors, it would say, okay, we'll pay out even though the vendor was at fault, and we'll then subrogate, we'll then go after under that contract, we'll take your place and go after the vendor. So that's been a big reason why people have bought insurance in this area. It takes that onus off you. Things like PCI are not a panacea, it's not a guarantee. There's been plenty of companies who have been compromised who are PCI compliant. And ultimately it is, as I say, balance sheet protection. Are you comfortable with that residual risk? If you've done everything that you should be doing, do you want to keep that risk on your balance sheet, or do you want to insure it? What does it cover? And a lot of things, but I'm really going to get, for today, focus on three things. Number one, and you've heard about this from Milo, the costs of responding to a breach, notifying the individuals, hiring an IT forensics firm, hiring a PR vendor, engaging with a credit bureau to offer what is typically offered, such as a year's worth of credit monitoring. That all mounts up in terms of cost, and insurance will pay for that. The two other things it'll pay for are liability. The first one was first party. The second one is a liability coverage, regulatory action, privacy regulatory action, whether it was the FTC or not. But if a regulator, such as the state attorney general, came after you, then insurance will cover costs of defending yourself against that action and the civil fine if you were so hit with one. Litigation, the third area, class action suits by your own employees maybe, or by your members, or by donors. In certain instances, we're now even seeing that from banks who have been issuing credit cards and have decided to sue the merchant for the costs of cancelling credit cards and replacing them, where they feel that the merchant was at fault. So when you're looking at insurance, 10 questions to ask your broker. How much insurance should I buy? Very often the question, that's a very difficult thing to know. It's a new area for the insurance industry as much as it is for everybody else. They're starting to get a handle on it, particularly on what we call those breach response costs, those first-party notification costs. Depending on who you talk to, that might break down into $30 to $50 per record breached. And crudely, if you think about a worst-case scenario and how much of that data you've got, you can multiply it by 30 to 50, then you start to get a worst-case scenario. But it doesn't mean you should buy that much insurance, but it's a rough rule of thumb. Liability outside of that, frankly, if you handle the breach right, then the liability side of it should hopefully be mitigated. You have less chance of a regulator coming after you or getting sued. Insurance carriers, I have to say to you that unfortunately it's a new area. It has been around for 10 years in this area in privacy, but what one insurance company offers versus another can be very different. So it's very important to understand that, what is being covered and what isn't when you're engaging your broker on this issue. But one of the big things that's perhaps come about since 2009 is some insurers are actually, and this might be important to you, offering services around handling the breach. So we talked about this earlier, but if you buy insurance, it may actually offer you a panel of vendors that will help you deal with it. So that would mean a law firm really to quarterback the process, followed by a bunch of other vendors in IT forensics and PR and so on, to credit monitoring. And that may be something that you'd be interested in. It may be something that you wouldn't be. You might find it too intrusive, but it is something that the market can offer. If there's litigation, can you use your own law firm? Topical subject in this room. And some insurance policies will say, no, we want you to use a law firm on our panel. Sorry about that. Well, if you know what you're doing and your broker knows what they're doing, then you can negotiate what we call mutual choice of counsel, and get the law firm that you want to use agreed up front. And that's important. That's very important. Claims experience of the carrier, I think that takes, you obviously want them to have experience in handling this area. Personal data, this goes back to what Milo was saying right at the beginning. Many of these policies will define personal data as PII or PHI. Well, that's not good enough if you have a breach of data in California. You need that definition broadened out on that insurance policy, otherwise the insurance isn't going to pay out. Are there any exclusions to do with privacy? Increasingly, many of these insurance products are really breach response products. But on the privacy side, which is it's a trickier risk to underwrite, such as things that are coming out of California around wrongful collection of data. You've taken someone's zip code and you shouldn't have done, so you're sued, or there's a regulatory action. Is the insurance going to cover that? That's very important, and there's a lot of insurers who don't. Breach response costs, number 8, sometimes are sublimited. You shouldn't accept that. Is there any limitation on coverage for that risk to vendors that we've talked about at all? Look at that. Look at what the insurance says about the contractual risk between you and the vendor. And finally, on point 10, make sure that what's called knowledge and notice of an incident is tied to the executive. You want it tied to as few people within the organization as possible. You don't want to impute liability to everybody. Otherwise, you'll find that insurance companies will try to crawl out of a claim because you, the whole company, knew about this, or someone out in the field, maybe a salesperson, knew about it, and it didn't make its way back and get reported in time to the insurance company. So tie that incident knowledge back to the executive team. Insurance market today is in this area. It's booming. Frankly, I mean it's a new area, as you can imagine, and you've only got to look at what's been going on last week and Target, and to see why it hasn't taken off in Europe for various reasons. It's a U.S. buyer at the moment. About over $1 billion in premium is spent in the market now. If you came to me and said, how much insurance could I buy, you could probably get $350 million, which isn't that much when you think that the property world is over $1 billion. But it's growing. About 50 insurance companies in the U.S. domestic market and in the Lloyd's of London, who are really the drivers of this. You know, I think, you know, as I said, the indemnity, you know, who's the vendor? Can I use my own vendors, or should I use the ones? Do I have to use the ones that are on the insurance solution is something to bear in mind. So with that, I'll just end very quickly and just saying there are other things coming over the horizon or are on the horizon. But, you know, the focus today has very much, I think, been on privacy, and rightly so, and that is perhaps the most imminent issue. But you will have heard of a phrase called the Internet of Things, and what that means. I'm not sure how relevant that will be, and Jeff can weigh in on this to this audience, but it may be relevant to you as consumers, certainly, as more physical things start to become connected. There are going to be implications, and not really necessarily privacy implications, but also things like physical damage and bodily injury. And you know, if any of you have watched Homeland and you saw the vice president's pacemaker get hacked and killed him, well, that actually is feasible. If you have a pacemaker with wireless connectivity, you can actually do that. But I mean, so it sounds sort of far-fetched, but you know, this is what's coming down the road. And driverless cars, as you will have seen, and what Google are up to in particular there. Big data, what are you doing with data and other privacy implications around that, and how you use that as your organization. And finally, the cloud, which we are, I think is a whole subject on its own, and we won't get into that for now.
We only have a couple minutes left. Ben, two quick questions. And I recognize it sounds to me somewhat similar to the nonprofit directors and officers liability insurance world, where there is no standard form. The policies vary wildly, the definitions vary, the exclusions vary. It sounds to be a lot of similarities to cyber insurance. But in terms of property damage and bodily injury, things that are similarly not covered by virtually all nonprofit D&O insurance policies, do most cyber insurance policies cover bodily injury and property damage?
That's a very good question, Jeff. You know, there's a politician's answer. It's actually a very topical issue right now in the insurance market because, if you look at the energy sector, if you look at critical infrastructure industry, where perhaps that's the most acute issue, what happens if a pipeline operator got hacked, and what are the issues around that, or Amtrak got hacked and a train derailed? It's all possible. Would the property policy or the GL policy cover it? Increasingly, the answer seems to be maybe, no, or on a limited basis. And at best, really, you're going to get silence on that. But what I will say to you is that risk has not been underwritten, because you've got policy wordings that are a hangover from a prior era, and now we're moving into risks that didn't exist before, and suddenly insurers are waking up and going, God. So you're probably going to end up in court, is what's going to happen if you're going to rely on that policy form to help you out.
And one other question, do a lot of these policy forms also cover violations of spam laws, email laws, and I ask in particular because we seem to get several questions every day in recent weeks on the new Canadian email law and the implications for nonprofits, because so many nonprofits have members, donors, supporters that they email in Canada, and there is a private right of action in that law that will take effect in July of 17. What sort of coverage is there for violations of either U.S. or foreign email and spam laws?
So on that one specifically, by default, most insurers exclude it, but if you know what you're doing, you can get that covered. So you can get defense costs, regulatory action, defense costs, civil fines, not criminal, civil. You can get those insured.
Thank you. And your point about getting regulatory investigation and defense costs covered is an important one also in the nonprofit D&O area. That's one of those areas where nonprofits are very grateful when they find they have coverage for what can be very expensive legal fees and other costs of defending federal or state regulatory investigations and enforcement actions, but not all policies will cover that. But with that, it is 2 o'clock Eastern. We are out of time. I want to thank Ben and Mila for a terrific presentation. Thank you very much. We hope to see all of you back here next month. Thank you.
Thanks, Jim.